The two cases that we'll be talking about today are the Bill 7 case, what's known as the Bill 7 case, the charter challenge to the law that the Ford government brought in, which allows them to discharge hospital patients. It actually requires that hospital patients who are deemed to be ALC, alternate level of care, so these are elderly hospital patients who are ready to be discharged to long-term care, but there is no available long-term care home to take them that they want to go to. It allows them to be forced out into long-term care homes that are not of their choosing, up to 70 kilometers away in southern Ontario, up to 140 kilometers away, 150 kilometers away, or even further in the north. And the second legal challenge, which is the Orchard Villa legal challenge, in which we sought a judicial review to quash the license to certain notorious long-term care home Orchard Villa, where more than 70 people died of COVID, more than 200 of 233 residents contracted COVID. The military went in, found terrible conditions. There have been routine terrible inspection reports in that home ever since Southbridge, which is a for-profit chain, bought it, and continuing, prior to the pandemic, through the pandemic, since the pandemic. Under the law, the government is not supposed to issue new licenses to companies that have terrible records in long-term care, but they have, and so we took it to court. In both of those cases, we lost, and we're here to talk about what our response to that and what we're going to do next. So I'm going to just turn it over to Stephen Schreibman, who is our lawyer from Goldblatt Partners LLP, and he's going to open up. I'll make a few comments after that, and then we'll open up for questions and answers. For the media in the Zoom, could you please just identify in the chat if you have a question? It would be great if you could say what your media outlet is too, just so we know to whom we're answering, or you could indicate by raising your hand, okay? Thank you very much. I'm just turning it over. Stephen Schreibman.
Okay, good morning. So in both of these cases, the court dismissed our applications. It disagreed with us on the law. The courts disagreed with us on the facts, and even held that our clients, at least the Ontario Health Coalition in the Bill 7 case and both of the applicants in the Orchard Villa case, didn't even have the right to, as public interest litigants, to raise the issues with the court. To say that we're disappointed with the results is an understatement. Needless to say, we don't agree with the court's conclusions on either the law, the facts, or on the question of public interest standing. Of course, the remedy is to the Court of Appeal when one is unhappy with the decision of the court. But the price of admission to the Court of Appeal is steep. Even at much reduced rates, litigation is expensive, it's very time consuming. There is the risk at the end of the day that you're going to be ordered to pay the costs of the other party. The challenges are daunting for any public interest litigant. When the court questions even your right to present the case and makes findings of fact, they're very difficult to reconcile with the evidence before it. The challenges are all that much greater. In the case of Bill 7, the applicants have decided not to seek recourse through appeal. In the case of Orchard Villa, the appeal and whether to pursue it or not is still under consideration. So just to put this, though, in a little bit of context, I've practiced law now for almost 45 years, and all of it has been in the sphere of public interest litigation. And in virtually every case that I've been involved involved with, from the sale of Hydro One to international litigation challenging Canadian environmental laws, to the student choice initiative that this particular government pursued in respect of the rights of students to organize and present their views. These cases were the last resort. We go to the courts, or typically non-governmental organizations go to the courts when all efforts to persuade governments of the mistakes we believe they've made in terms of policy and law should be corrected, when whatever public pressure there may be that's been mobilized to further persuade governments to make the changes have failed. So when the stakes are high enough, when the harms of the particular initiatives or policies or laws are severe enough, you go to court, because there really is no other recourse. And that's exactly what's happened here in respect of the rights and interests of, this constituency in our society of elderly people who are no longer able to care for themselves and who cannot, in part because of the lack of support for home care, who cannot be cared for in their community. So that's the common thread that joins these two cases together. It's about these people who are frail, who are ill, who very often are suffering from dementia, and how we as a society are going to treat them, and whether as a society we're going to provide for their proper care and safety. So whatever the court might decide in cases like the ones we've brought, ultimately the remedy is one that the government has to address or establish. There's nothing the court can do to create more hospital beds. There's nothing the court can do to create more long-term care homes or better long-term care homes, or to ensure that long-term care homes are actually capable of caring for the people that are entrusted to their care. And so we are in a sense where we would be even had we won the case, which is to persuade the government of the need for reform and changes to the system of healthcare as it addresses the needs of these people in our society. And in that regard, the cases, I think, are helpful, even though the court didn't agree with us that they should issue a remedy. And they're helpful because of the evidence we were able to gather to expose the circumstances surrounding the implementation of Bill 7. I'll refer to it as Bill 7 because describing it as the More Beds, Better Care Act is rather grotesque, given the fact that of course, the bill doesn't create any more beds and certainly doesn't provide anybody with better care. In the Bill 7 case, we were able to gather a lot of evidence and have the government produce evidence that revealed whether there was any justification for the law, whether the law is working, and what, if any, consequences it has had for people seeking care in long-term care homes. And so the first thing we discovered in gathering and putting together the evidence, including evidence of 6 experts on the issue of this patient cohort of patients in the hospital waiting for placements outside the hospital, with some of the leading experts in Canada and internationally on the issue, but also evidence that had been gathered by the government and published by the government that I don't think had previously come to light, at least not outside the circles of a small group of people in the healthcare system. So there are ALC summaries of what's happening in the province with all these patients that are published every month by Ontario Health. And those summaries revealed that in the first full year of implementation after Bill 7, 2023, the number of ALC patients in waiting in hospital went up by 34%, and they were waiting significantly longer for placement in a long-term care home. So there was, not only did that evidence reveal that the bill wasn't working, but that actually the situation was getting much worse. And among the reasons for that, certainly the lack of hospital beds, the lack of beds in long-term care homes. There are about 75,000 beds in long-term care homes. The wait list for those beds are almost 65,000 people long. That includes a lot of people in long-term care homes waiting to move to another long-term care home, but about 40,000 people outside the system. But one of the things that we were able to establish in evidence was that in some ways the bill was actually making the situation worse for two reasons. One is by giving ALC patients in the hospital priority over all others, including those on the crisis list for placement at a long-term care home. For those people waiting outside the hospital, giving the limited availability of beds in the system, the only reliable way, or the most reliable way in order to get a bed would actually be to get admitted to hospital. And there are physicians that are advising their patients of that. If they're desperate, they're at home, they're waiting for a bed, they really can't be cared for. These people are very ill. The life expectancy of residents in long-term care homes is only 1.5 years, and these people are often sicker than the average. Go to Merge and get yourself admitted to the hospital, because that's probably the only way you might find a bed in a long-term care home. The other problem with the Bill 7 regime is that by increasingly placing people in homes that can't care for them because they're either too far from their families, and one of the secrets or one of the things that is propping up are the inadequate long-term care system we have in the province is the fact that if you've got a partner who's alive and you're in a long-term care home, or a child that's able to visit you, there are an awful lot of those partners and children that spend every day visiting a long-term care home to help their parent or their partner feed or toilet or all of the other things that are necessary. And so not only is that crucial for their well-being, but it also alleviates the burden on understaffed long-term care homes to actually care for other patients. So you put people in homes that can't care for them because in part they're not getting the support of their family because the home's too far away, and we have a witness who described that in some detail. But the other reason is that you put people in homes that can't provide the actual healthcare service, and in particular palliative care. So there was evidence from the Canadian Institute of Health Information, from our experts, and peer-reviewed studies that showed that if you go into a home that can't provide palliative care, you have an increased risk of mortality of 10% and a 25% increased risk of being readmitted to hospital. So you stick people in a home, and these people are ill, and they're on the final days of their lives, and if they're often simply readmitted to the hospital because the long-term care home can't provide care for them. So they either end up being shunted back to the hospital for palliative care, or they actually die in these long-term care homes without the benefit of palliative care. It's a very tragic scenario, but it's one of the explanations for why the numbers are going up. Not the only, certainly. So the first thing we learned about the regime is that it isn't working, and we learned a fair bit about why it isn't working. The second thing we learned is that there are no bed blockers. The ostensible rationale for depriving this particular group of people and them alone of their right to informed consent over the health care they receive and where they will spend their final days is that we had to take that right away from them. The very limited opportunity to influence where they would spend their final days because they weren't being reasonable about the choices available to them. They want to go to a particular home, that home isn't available, so they're simply happy to stay in the hospital. There is no evidence that such people exist. The government called evidence from 3 hospital CEOs, from 3 doctors who are specialists in managing the flow of patients through the hospital, from the regional director of home care and community support services, and none of them adduced evidence that even one person was in the hospital because they wanted to be in the hospital and simply refused to accept the limited options available to them. Our experts who deal with these patients routinely say that what happens when somebody ends up in the hospital because of an acute care event, and that's resolved, the person wants to go home. And it's a great shock and disappointment to them and their families when they discover that's simply not possible. That they have to leave the hospital for a long-term care home. If they have the resources to do so, they can research where that might best be. And when they're informed that let's say they're unilingual Chinese speakers, that they can't get into a Chinese home, or they're Jewish and they want kosher food, that's not available to them, they're further disappointed or even crushed by the fact that there's limited prospects of them getting the care they need. But when the reality of their circumstances is explained to them compassionately, they accept the fact that they're not going to be able to go to a home they would prefer to go to, and they leave. They don't want to stay in the hospital. The hospital isn't equipped to care for them. So in all of that evidence adduced by the Crown, not even one patient was identified as falling into the category of individual that simply needed to be deprived of their consent because they were being unreasonable. In cross-examination, I got to cross-examine these witnesses. And I asked, well, have you ever encountered anybody like this? And when I questioned Dr. Pelk, who's at Mount Sinai and Bridgepoint, and he said, yes, 2. And I said, and how many years of practice? 7. And how many patients do you see a day? About 33. I mean, that's really the only evidence that anybody like this exists. And it wasn't that they hadn't chosen a home, it's that they were admitted to a home, they didn't want to go, and who knows why that is. The doctor didn't inquire. So bed blockers don't exist. The fundamental rationale for this scheme simply has no foundation. The third thing we learned is that there is a great deal of harm being caused by the regime by making it more likely that somebody's going to end up in a home that's too far from their families to provide care, that is less suited or ill-suited to providing the health care they need, whether palliative care or other types of care, and that indeed people are suffering more and their deaths are being hastened, as our expert evidence witnesses attested to. Now, the remarkable thing about this evidence of harm is that it wasn't disputed by the Crown. There was no argument that these facts and this evidence were false or unfounded. Yet the court decided in the Bill 7 case that in fact there was no harm that was being suffered by ALC patients, and that the only consequence for them was the inconvenience of having to spend $400 a day should they remain in hospital after they were admitted to the home they hadn't chosen. And so I think what's most important about this disconnect between what the court found and what the evidence was that was adduced before it, that was not being disputed at all by the government, is that no one take that conclusion as valid. So those who actually care about whether the system's working, about whether the compromises of Bill 7 in terms of depriving ALC patients of rights are justified, for those in the policy sphere or in government that need to make decisions about these matters and correct the errors that Bill 7 engenders, that is not a conclusion that in any way can be reconciled with the evidence before the court. That's, I think, the most important point I want to make about the Bill 7 case. In the case of Orchard Villa, the evidence really speaks for itself, but what that case allowed us to do was to pull back the curtain on what the ministry is doing to ensure that long-term care homes are actually capable, the operators of them are actually capable of providing the care that they're required to provide. And there's a very important test in the Long-Term Care Act when someone applies for a license, and that is that they are determined to be eligible on the basis of their past practice of providing proper care for residents and complying with the regulations that establish the need for providing that care. And in the case of Orchard Villa, its record couldn't really be worse. And it didn't just come to light come to a peak during the pandemic. It's been endemic since the home was acquired in 2015, and certainly became notorious during the pandemic, been the subject of study by the Long-Term Care Commission, the Ombudsman, and the Attorney and the Auditor General in Ontario, and most remarkably continued after the pandemic. And what was most surprising to discover in getting the government to produce its record of decision, in other words, the evidence that lay behind the director's decision, we got 7,000 pages of material. And what was missing in that material was the regulatory record of the home in the 2 years prior to the issuance of the undertaking to issue a license. So the very most recent information about whether this home was complying with the Act, whether it was providing proper care, wasn't included in that 7,000 pages. We had to adduce it through expert evidence of Pat Armstrong. And she had that evidence because it's actually published by the ministry on its website. All of the inspection reports that were carried out during that 2-year period are published. It shows a continuing pattern of regulatory noncompliance, including noncompliance with infection prevention and control procedures required by the Ministry of Health and local health officials. And not only, those are the very types of noncompliances that led to the catastrophe at the home during the pandemic, they persist after the pandemic. And in fact, there's a director's order citing the home for not only not complying with the IPAC procedures, but falsifying its records in order to cover up its non-compliance. So again, you have a great disconnect between the judgment, if if you read it, and the evidence that was adduced before the court, because you won't find reference to that huge gap in the record of decision-making before the director. So another very puzzling treatment of the evidence by the court. So Natalie wants me to wrap up, so I'll do that. I want to make one final comment about the issue of standing. These are public interest cases. In both instances, the court found that because the Ontario Health Coalition isn't incorporated, it isn't a legal person and shouldn't be present before the court, there is no bar to allowing, certainly our argument is there's no bar to allowing a group like the OHC to have standing in a case like this. But the need for legal person status is simply entirely out of place in public interest litigation where there is no private right being asserted. This is a non-governmental organization asking the court to supervise the constitutional validity or the administrative compliance of governments with both the Charter of Rights and Freedoms in both cases and the laws of the province, in particular with respect to the licensing of long-term care homes. So I'm a little over time, but I'll wrap up there.
Sorry. Okay, I'm going to scoot you over. Okay, I'm going to be super quick. I just wanted to say that our reaction to the judgments, we're shocked and we're dismayed. Obviously, we did not expect this result, and it impacts really literally more than 100,000 people now, and in coming years, untold hundreds of thousands of Ontarians. Both of the judgments do, and it's really a problem. I was talking with the families of Orchard Villa. And the reaction of one of them was just to almost be in tears that no matter what they've done to try and seek accountability or justice or change, nothing has worked. I mean, it just hasn't happened. The media might be surprised to know that despite the round of press conferences and media, that we don't even have annual surprise inspections, the comprehensive annual surprise inspections back in long-term care homes. Every protection that we won in legislation over the years to try and protect the public interest in long-term care homes has failed. We're supposed to have annual comprehensive surprise inspections. They are not happening. There's no enforcement without inspections. The law says that if a corporation has a terrible record of non-compliance with the act, that it doesn't meet the standards, that it puts the lives of its residents at risk, they should never get a new license. It actually forbids the ministry from issuing a new license. That was won in legislation. And, this court judgment says to me, why do we have a legislature? If the court won't uphold that the legislature has to do what's in the law, why do we have a legislature? What does it even mean? And how are we supposed to be able to achieve any accountability for following what the legislature in Ontario has voted for duly and passed into law? It's very frustrating. My heart is broken for the families of Orchard Villa. It's emotional. So many of them died in such horrific circumstances. The fact that Southbridge is not only going to be never held accountable in any way, but that it's actually being rewarded with a massive expansion and a 30-year new license that the public is paying for in Ontario remains absolutely shocking to all of us. I'm very saddened by this. We have not made a determination about the next steps in that case. At this point, we have to hear about costs from the government. And so if you lose a case, you not only have to pay your own legal costs, but you can also be required to pay the government's costs, for legal costs for the case. We're waiting to hear about that one and figuring out what to do. On the Bill 7 case, this the actual ruling was very shocking to us. The court said that the harms to ALC patients, these elderly patients waiting in hospital to go to long-term care, were modest. They don't affect the life, liberty, equality, autonomy of those patients. The court ruled that the requirement to pay $400 per day was not coercive, and described it as a modest economic consequence, saying that the consequences were not serious. That is not our experience. I mean, our experience is that, families call, they're in absolute crisis, their loved one can never go home again. They've just had a, major healthcare episode of some sort and found that they can't go home again, and now have to find somewhere for them to live. And then they're being threatened with $400 a day unless they go to the long-term care home in the area that nobody wants to go to for good reason, because it's a terrible home, because they can't provide the care, because it's in, terrible condition and doesn't have staff, or because it's so far away that their loved ones won't be able to get there in the last dying days of their family member, their spouse usually. It's horrific. It crosses all of the moral boundaries of our society. The majority of Ontarians don't agree with treating people in the last days and months of their lives in this way. And we agree. The fact is that law targets one set of patients, elderly patients, for this treatment. No other set of patients is treated this way. And so we argue that this was discriminatory against the elderly. The court did not find so. We're not appealing because we can't afford to appeal, frankly. That's just the bottom line. It's, hundreds of thousands of dollars to do these cases, and the only money available is what we can raise from the public, from concerned people. So we can't appeal, but we can continue to fight for policy change in this area. And the fact that the ageism in our health system is so profound that it really does treat the elderly in ways that would not be acceptable for any other patient, will continue to raise that very valid issue. Now we have to push for policy change with the Ford government. At this point, Ontario has the fewest hospital beds left of any province in the country, and we're third from the bottom of the entire OECD. Only Mexico and Chile have fewer hospital beds left than Ontario. At the same time, the government has failed to build long-term care beds or expand home care to meet population need. And the answer cannot be to blame patients, to put patients through inhumane, even cruel treatment in order to force them out of hospital to inappropriate places. The affiants, the families that provided witness testimony to go to court with us, described the harm and suffering that they had as a result of this legislation. One of them, her loved one ended up living in a dark room that was dark all the time with no programming, almost no programming in the home, no recreation, no programming, severely understaffed. They would have to wait for an hour and a half to be toileted, that there was inadequate physiotherapy. Another one described her loved one, because he was moved too far away, her husband, her spouse of like 60 years, ended up in a home where they drugged him so that he would stop calling out for her because she couldn't get there to see him. So they used drugs as a restraint. That was the consequence of this type of legislation. So respectfully, in our view, yes, it does create harm. The consequences are not modest, and $400 a day is $12,000 a month as a penalty if you don't go to a home that you don't want to go to or is too far away. That is completely unaffordable for the vast majority of people. So we'll raise this as a policy issue. We'll fight as hard as we can. We'll try to bring to light what's actually happening to the patients and the people affected by this legislation. And, at some point, the fact that it crosses the moral code of people, that there is a line that you cannot cross, and they're over it now, has to kick in. And there has to be enough pressure on the government to actually address the shortages that have resulted in this legislation. So with saying that, I'll turn this over for questions and answers. Sorry to take so long. And so, Sala, are you on the Zoom? So will you identify the questions on the Zoom? We'll start with the room, yeah.
You mentioned at some point there'll be a sort of turning point where this won't be acceptable. But in the meantime, like, how do you fight this? The courts have basically said this isn't the place, or have given you that idea and you decided not to take it further for other reasons. The government who put this into place has just been reelected. They feel they have a strong mandate on all fronts, it seems. So, I mean, what are your options? Like, how do you fight this?
I think we're going to take a little time. I mean, obviously, we're not going to kick a government when it's down. We're in the middle of a big trade war with the United States, and it's not the time for us to be mounting major public pressure on the government. When things are more stable, we'll be figuring out how we can make the most visible possible what's actually happening. Because it's kind of like in long-term care for all of those years, it was hard to get patients to speak up or families because they were afraid of retribution. They're vulnerable, right? They're in the health system that if they complain about it, then they get counter complaints of abuse and so on, or they feel like their loved one is going to suffer consequences of not getting good care and so on. In the case of the Bill 7 families, the people being forced out of hospital, they're in the middle of having a fight with a hospital while their loved one is in a health crisis and a housing crisis. And it's very hard for people to complain. But we have a lot of families who are in that circumstance, and I think we have to make it visible. I think that's going to be the first thing. We're going to try and we're asking for people to come forward. We'll hold press conferences with the families describing what is happening to them, and that sort of thing. We'll have to organize protests. People need to see a visible fight back and have a way to join, and we'll have to organize pressure on the MPPs. That's what we can do. It's not to say also that maybe down the road, families couldn't bring another case forward on Bill 7. I'm not sure. So we'll also see if that's a possibility.
Are there people raising their hands online?
Yeah.
One person? Go ahead. Can we do like one-on-one interviews after?
Sure, yeah. Okay, so the question online? It's Randy? Go ahead, Randy.
Hi, Natalie. Thanks for taking our questions. My first question, I guess, first of all, is just how successful do you think you can be now with another majority government in place?
Well, you know what? I mean, over the years, I've done this now for almost 30 years, and we've won all kinds of policy change with majority governments in place. And often, we've had governments substantially amend their own legislation and so on. It's absolutely possible. The problem is that the Ford government has been particularly intransigent. Like, we've met with every premier and every health minister for all of the decades that I've been involved, except for the Ford government. We've amended every major piece of healthcare legislation for the last 30 years, except the Ford government has not accepted. They voted down all amendments that weren't their own to every piece of healthcare, every major piece of healthcare legislation they brought in. They're a very difficult government. We haven't, no health minister under the Ford government has met with us, and that's routine for them. They don't meet with people they don't agree with or that they don't like. It's a problem. So I don't know if they're going to change their ways at all. We'll pressure for them to change their ways, but we have some problems because the normal democratic processes have not worked with this government. So we'll have to continue and just ratchet up the pressure outside of government to try and pressure the local MPPs, to pressure their own caucus for change. That's all we can do. And eventually, there's always a break. Even in the darkest days after the 2008 recession, when we were facing major cuts and all, and it just wouldn't stop, there ends up being a break and you actually are able to achieve things. So, something will shift and will create the conditions that in which there is as much public pressure as possible. Anything else? Okay. Okay, thank you very, very much for staying with us. Thank you. I'm going to end the
Oh,
Zoom.
Sorry,
Oh,
Natalie?
sorry. Yeah, go ahead. Did you
Yeah,
have a
no, I
follow-up?
got muted there and I did have another question.
Sorry,
So,
Randy.
yeah, no problem. So at the beginning of all of this, and particularly the Bill 7 challenge, I recall you at a press conference saying that these issues do cost a lot of money to fight. So I
Yeah.
was wondering if, did you get a lot of public support at the beginning of this, or was the amount of support that you received to proceed with the challenge just not enough to go with an appeal as well?
Yeah, like we haven't even paid off the cases yet. I mean, it's like hundreds of thousands of dollars to do this work, and so we haven't paid off the initial cases yet. We would have to raise additional money for the appeals, so it's just not possible. And what it would mean is that we're not able to do the other work. And an appeal in any case, and Stephen can elaborate, but an appeal in any case is a steep hill to climb. You know, you have to, the upper courts, as we understand it, are more reticent to overturn the verdicts of lower or the rulings of lower courts. And so it would be a steep hill to climb no matter what happened. But we would also have to have the money to do that with a high risk of not being able to succeed. And I don't know if you want to add anything to that.
No, that's
Good, yeah. Okay, and I'm very, very sorry for the families. I'm sorry that we can't appeal. I really am. I just, it's just not doable for us. Thank you. Okay, I'll let you go with that. Thank you.